Hi guys, welcome to Legal Brilliance. Today we are going to discuss an important concept of Indian evidence law, character evidence, section 52 to 55 in detail. Let's begin with the introduction. Character evidence, it simply means evidence as to character of the individual. And that is the reason it is very important both in civil and criminal law to determine the guilt of an individual. Section 52 to 55 of Indian Evidence Act 1872 deals with character evidence. Meaning, character simply means a combination of qualities which distinguishes one person from another. The individual attribute is the product of nature, habit, and environment to which he is subjected to or to in which he lives. Generally, character is something which lies in the man and it is the mark of what he is. The traits of character includes is a man honest, good-natured, violent temper. So these are the traits of a man's character. According to section 55 of the Act, character includes reputation and general disposition. Reputation generally means a belief or opinion that one person holds about someone or something, whereas disposition means a usual way of behaving. Relevancy of character in civil cases, section 52. General rule. In civil cases, evidence as to character of a party is irrelevant. However, evidence as to character of the party is relevant in civil cases when the character is itself a fact in issue. To understand the character is itself a fact in issue, let's look into an example. A files a suit for divorce against B on the grounds of cruelty. Here, in the civil case of suit for divorce, ground for cruelty, the ground of cruelty is the fact in issue. So the character of defendant B, that is the cruel character of defendant B, is the fact in issue, and that is the reason plaintiff A can lead character evidence in the suit for divorce. In simple terms, fact in issue is the main cause for action. That is, the main cause for suit for divorce is the cruel character of defendant B. Second example, the character of female chastity, it can be received in evidence in action for breach of promise for marriage. Section 52 has an exception, but the general rule is that no evidence can be given as to character of a party to a suit. The exception to this rule is that the court may form its own opinion or own conclusion as to what is the character of a party to the suit. This, the court can draw inferences whether he is guilty of the conduct imputed to him or not from the evidences that is exhibited in the case. In other words, to say, the court may decide as to what is the character of the party from drawing inferences from the evidences that is exhibited in the case. Relevancy of character in criminal cases, section 53. In criminal cases, evidence of previous good character of the person is relevant and is always admissible in the court. Character is generally material consideration in criminal cases, and sometimes it is also conclusive proof to determine whether man has committed an offense or not of which he is accused of. Example: a man is accused in a bribery case. He pleads and produces evidences of his good character. Now, this evidence of good character will become relevant in the court. When previous bad character is relevant. Section 54. The previous bad character of accused in criminal case is relevant in following circumstance. First, to rebut prior evidence of good character. In case the accused has already given evidence of his good character as a defense, to rebut such prior evidence of good character, evidence of previous bad character can be made admissible. Second condition, the character is itself a fact in issue. In case of habitual offenders who are by habit or by nature a robber, housebreaker. Third condition, in case of his previous conviction that shows the previous bad character of an individual. Character as affecting damages. Section 55. As per Section 55, character evidence in civil case is relevant and admissible because if it is not made admissible, it can affect the amount of damages that are to be received. In other words, bad character is admissible in mitigation of damages provided it is justifiable. Example, in case of defamation, general bad reputation of plaintiff may be proved. Example, A files a suit for defamation against B. Now B, the defendant, can plead and produce evidence as to general bad reputation of plaintiff to reduce the amount of damages that is caused to him because of A's action of filing suit against B. Here, by proving general bad reputation of plaintiff, the defendant is in a better position to prove before the court that a man who is of a bad reputation, how can he describe whether someone is of a good or a bad character? Generally, character evidence or a character includes both reputation and disposition of a person. This is defined under Section 55. That is, reputation means what is thought of person by others or the general opinion of others. Disposition generally means it is a texture of the mind or the usual way of him behaving in certain way. Consideration. Under Section 55, there are two considerations. Evidence of those who know the man and his reputation is admissible. Evidence given by a person who knows the other personally, his evidence of that person's reputation can be made admissible. Wherein, in the second condition, evidence of those who do not know him personally but have heard of his reputation from the other person. This is a clear illustration of hearsay evidence, and generally, it is known that hearsay evidence is no evidence, and that is the reason it is not admissible. It is noteworthy to understand that character under Section 52, 53, 54, and 55 includes both reputation and disposition. With this, we come to the end of our discussion on character evidence. Thank you.